In this lesson, we will talk about drafting legal opinions in sanctions compliance, purpose, structure, best practices, and specimen analyses. Legal opinions are the gold standard for defensible, board-level decision-making in sanctions compliance, especially where conflicting US, EU, and UK regimes create acute legal risk. Their structured format, rigorous analysis, and actionable recommendations are essential for regulatory defense, transaction clearance, and risk mitigation in complex, multi-jurisdictional scenarios. Legal opinions in sanctions compliance serve as formal, defensible analyses of how sanctions laws apply to specific facts, particularly in cases involving multiple jurisdictions or ambiguous regulatory requirements. Their primary purposes include demonstrating good faith, reasoned compliance to regulators and courts, supporting or rejecting high-risk transactions, such as those involving indirect SDN ownership or conflicting obligations, informing senior management and boards about legal risks and consequences, and providing rationale for license or exemption applications to regulatory bodies like OFAC, OFC, or the EU Commission. These opinions are typically drafted by external law firms or in-house counsel with expertise in sanctions law, and are relied upon by boards, compliance officers, banks, corporates, and regulators to make critical decisions and engage with regulatory authorities effectively. The standard structure of a sanctions legal opinion is designed to provide a clear, methodical analysis for addressing complex sanctions compliance questions. It typically begins with an introduction purpose, which states the questions addressed, the context, and the intended use of the opinion. The factual background follows, outlining relevant facts, transaction details, parties involved, and any assumptions made. The applicable legal framework summarizes the relevant sanctions laws, regulations, and guidance from jurisdictions such as the US, EU, UK, and UN. Next, the legal analysis applies this framework to the facts, addressing specific issues like the OFAC 50% rule or the EU blocking statute. A risk assessment evaluates legal, regulatory, and commercial risks, including potential penalties, while the recommendations section offers actionable steps, mitigation strategies, or alternative options. The opinion concludes with disclaimers and limitations, clarifying the scope, reliance, and limitations of the analysis, and may include appendices containing supporting documents, statutes, ownership charts, or other reference materials. This structure is widely recognized by major law firms, ACAMS, the Wolfsburg Group, and regulatory guidance as a best practice. At this point, we will make a comparative analysis of legal opinions, compliance memos, and regulatory submissions. Legal opinions, compliance memos, and regulatory submissions are foundational but distinct document types in legal and regulatory compliance. Each serves a unique function, carries different legal weight, and is relied upon by different audiences. Understanding their differences is critical for effective compliance, risk management, and regulatory engagement. Legal documents serve different purposes and audiences depending on their type. A legal opinion is a formal legal instrument that provides a reasoned legal conclusion. It is highly structured, cites relevant legal authority, and is often privileged. Its audience includes boards, regulators, and counterparties as it supports informed decision-making. Due to its formal nature, recipients may rely on it, and the issuer assumes professional liability. A compliance memo, on the other hand, is an internal advisory tool used to guide compliance processes and manage operational risks. It is moderately formal, focusing on practicality rather than rigorous legal analysis. Unlike a legal opinion, it is not privileged and carries limited legal weight, as it is intended for internal teams rather than external stakeholders. Liability for the issuer is minimal since it is not meant to be relied on externally. A regulatory submission is a formal and regulated document such as a suspicious activity report, SAR, or license application. These documents are submitted to regulators such as OFAC, FinCEN, or the FCA, fulfilling legal obligations and potentially triggering regulatory action. Regulatory submissions follow strict content and formatting standards and are legally binding, often relied upon by regulators or law enforcement. Legal opinions, compliance memos, and regulatory submissions each play a distinct and critical role in the compliance ecosystem. Legal opinions provide authoritative, privileged legal conclusions with significant reliance and liability implications. Compliance memos serve as internal guidance with limited legal weight. Regulatory submissions are formal, binding communications with regulators, carrying substantial legal and evidentiary consequences. Understanding these distinctions is essential for effective compliance management and regulatory engagement in sanctions, and broader financial contexts.